Hey folks, Greg Siskind here, along with Ari Sauer. It's nice to be back. You may notice the blurred background instead of my usual office background that I have. I am in a hotel. I am in Mexico City right now, and seem to be getting pretty good internet, and everything seems to be working well. But I said last week I had something nice going on in my life that was happening here, and I have one of my children is getting married this weekend. So we're here along with a bunch of family for this wedding, but it's not till the weekend. And I looked at my schedule and I said, I could do the live stream tonight. I told people last week I probably wasn't going to be here, but I'm back mainly because, well. Actually, I thought Ari was going to be one I was going to be the one with the internet problems. Hopefully, Ari will be back here in a second. But hopefully, but anyway, the breaking news tonight, or this afternoon rather. Here's back. You're back.
Sorry, I realized I didn't have all the features, and I realized I had not signed into my account. And,
okay, well, you're back.
I tried doing that, but it did. So I just so you know, I won't have access to change the banners.
That's okay. We're not. Yeah, we're covering fewer things tonight than we usually do because they're big things that we're talking about. So there's not probably as needed for the banners as much. But if you got them, Barry, you're welcome to put them up. But what I was saying is that we had some big developments in the last couple of days, so I thought I would come on tonight, even though I didn't think I was going to be. And I'm glad I have Ari joining me because Ari has been around a lot of years and has seen everything in this space. Not quite everything, but quite a bit. And we want some of your wisdom
20
tonight.
Years or so. Are we recording this, Greg?
Yes, it is.
Okay.
It's all recorded, so people can watch it that are missing it live. All right. So the things we're going to talk about tonight are bans and pauses. And let's see. We have one nice there's one good news story in immigration this week. And Ari and I both work on those kinds of cases. We'll talk about that. But I wanted to get started by telling people that with respect to the 39 country ban, so this is the ban that is both a this was a ban that covers. There's a lot of reasons for it, but basically it did three things. One is it banned the issuance of visas. Two, it bans entry to the United States, and three, it's paused all immigration benefits for people from those 39 countries. And the immigration benefits range from anything from a simple work authorization application to naturalization to green card applications, I-129s, and you name it. Basically, it's just about everything that USCIS adjudicates on behalf of people from those countries. So we had this ban for a couple of weeks. One of the issues that we litigated quite a bit against the first Trump administration, but also sued President Biden over it as well, was the idea that INA, the Immigration and Nationality Act, Section 212F, gives the president the authority to bar the entrance of an individual or group of individuals if he deems it in the interest of the country. And there was a Supreme Court case on this called Trump v. Hawaii, and they basically made it clear and limited of what the president could actually could do in that space. And the president essentially had to offer findings for Congress, and the public on why they were issuing this ban. They had and there were other things in there that had to be included in that. But it's always been, if you look at the precise language of these bans, it's always been about entry, which basically means when you show up at a port of entry, at an airport or on land or on the ocean, you have to seek entry from CBP. That's what he can cover in Section 212F. He can't do anything else under Section 212F but bar entries. What that means beyond that is that you can't ban the issuance of visas and you can't pause the issuance of benefits under citing Section 212F. So the administration has done all three of those with the with this latest set. They had the proclamation itself, which only talks about visa issuance and entries, and then they issued a memo at USCIS saying, by the way, if you're covered by one of these bans, now you're going to be we're going to pause your adjudications based on that, which is essentially extending Section 212F to domestic processing. So we filed a lawsuit at our impact litigation group last Friday. I think we had about 350 plaintiffs in that case. We're asking for the benefits pause for the memo to be basically struck as illegal. But at a minimum, we're seeking to get help for our plaintiffs, but hopefully it'll be for the broader group. We certainly have asked for a judge to strike it down altogether. That was suit number one, which we filed on Friday. Suit number two is a suit that we are gearing up to file. Probably could be this week, it's probably more likely going to be middle to late next week, where we're suing the State Department over visa bans because, again, 212F doesn't allow for the banning of visas. It only allows for barring people from entering the United States. And there's actually quite a bit of case law on that, including 6 cases that we won in the first Trump administration on behalf of fiancés. Including our Milligan case, where we had 900 couples in that case. I think that's the largest number of plaintiffs I've ever had in any of our lawsuits. But in that case, you may recall, going back to the COVID days, there were these travel bans that would be issued that said that you couldn't be, it seemed like every week there was another country that was having an outbreak, and they would issue a travel ban saying, if you've been in this country in the prior 14 days, you're not allowed to enter the United States. Fair enough. But what was happening at the consulates was they said, we're now on a travel ban list. We're canceling all appointments for everybody. And for the fiancés, it's like, hey, I'll go wait in another country for 14 days and then enter the United States because I need the visa and I'm willing to abide by the terms of this ban. And that was the judge agreed with us in those cases. We also had a case for diversity visa applicants, similar, that were from travel ban countries that we were successful with in the first Trump administration. So we are retooling that case for the story we're going to talk about next, but I did want people to know where we are on that litigation. I also wanted to let people give people an update on other cases other lawsuits that we are working on. That includes the H-1B $100,000 fee lawsuit. Just to catch you up on that, basically there's 3 lawsuits that are pending around the country. One of those lawsuits is the U.S. Chamber of Commerce suit in the District Court in Washington, D.C. Another is a suit by the attorneys general of 17 states that was filed against the administration in Boston. And then there's our suit that was filed in San Francisco, which is on behalf of really a wide range of plaintiffs that are not big companies and are generally not IT. Although there are some amongst our plaintiffs, but there were a lot of healthcare plaintiffs. There were religious organizations. There were tribal schools, all kinds of plaintiffs that were in our suit. So the Chamber case, a lot of you probably saw in the news, they got a bad decision from the district court judge. And fortunately, They appealed quickly in that case. They have a briefing schedule that the judge has accelerated because not the judge, but the appellate court is accelerated so that they can get a decision before the lottery happens in March for H-1B visas. And that has, we just saw the chamber's opening brief for the DC Court of Appeals, which I thought was excellent. And they really leaned in hard on the argument that $100,000 that the $100,000 is a tax, and a tax can only be created by an act of Congress. The president can't unilaterally issue taxes unless he has been given that authority by Congress. So, I mean, arguably, he has some authority in the tariff space, for example. But there's the administration is trying to argue that this is a simple immigration fee, even though there's no connection between. There's been a lot of litigation about fees over the years, and you do have to show there's some connection between the dollar amount and the actual cost of working on the case itself. So I think the chamber's on the right track on that. It wasn't something that seemed to get a lot of traction at the district court level, but hopefully the appellate court will give it due consideration. I don't know where the scheduling is on the Attorney's General case in Boston, but I can tell you, in our case, we have we're scheduled, I believe, for our briefings and all that. Everything's going to be done, and we actually have oral arguments for our case scheduled, I believe, February 19th, and we'll probably have a decision shortly after that. So hopefully, we'll one of these three cases is going to do what needs to be done and get this proclamation struck down. But that's where we are on that case. And I know a lot of people are watching on that. So, Ari, I think it's time to turn to today's news, which, usually we see it coming. I think on this one, I guess we saw it coming just because it seems inevitable that one step after the next, the administration is trying to shut down processing of visas as much as they can. So what happened today? So give the broad outline of what happened, or I can.
So today we started hearing rumors. It started as rumors, even Reddit discussions. There was an announcement of an expansion of a visa halt. And throughout the day, we getting little bits of information through the news or through various rumors.
Yeah,
the Department of State finally issued this evening issued a statement. Although, as you pointed out, there doesn't seem to be a proclamation actually attached to this, right?
One of the news reports said that there were secret proclamations, which is something that we haven't seen before. And I don't know how reliable that is. I don't know which is worse, that, having secret proclamations or doing this without any proclamation. But in either case, we don't have, if you go to whitehouse.gov right now, you're not going to find anything on this. So that's Ari, I think the other thing I found surprising was the list of countries, which I don't know if people can read it on the screen. You can certainly go to the State Department website and see it for yourself. There are several countries on here which have already been, have bans on them, but there's a lot of countries.
The reasons for giving this ban are different this time. The reason for this ban are to keep people from becoming public charges,
right?
Which we already have rules in place on.
It was pretty obnoxious, but basically the social media that came out today from the State Department basically insinuated that all these people were, as soon as they get here on immigrant visas, are accessing the welfare systems And basically, I mean, well, that's nonsense. First of all, even if you come in on a green card, you're not eligible for any of those benefits, at least the federal benefits, for at least 5 years. And that should be the only thing that that is of issue for the State Department.
Well,
but
plus, we're also, as part of for these immigrant visas, these are either employment based, in which case they're coming here for a job that pays,
exactly.
to be here, or they're coming as a family member, and the family member is required to show that they have sufficient funds to support the person coming in, so that they will not be a public charge. So there already is a process in place to keep people from becoming immigrant visa applicants from becoming a public charge.
All right. The other thing that the administration can do, if this was not just a pretext, which I'm pretty sure it is, for trying to keep immigrants out of the country, but if this was the real concern, I suspect that the votes are there in Congress to make it 10 years or 15 years before people could access those kinds of public benefits. But there have been no proposals to do that. And that's because this is a pretext. This is not something I think that the administration is really this is a real concern for them. With that being said, I did want to tell people about a couple of observations that I had that, I think, well, first of all, this is, by the way, goes into effect January 21st. Right. So, and it's only affecting the issuance of a visa. So if you are in a situation,
it's only affecting immigrant visas, those applying for permanent residence. It does this expansion to those countries that are expanded does not affect non-immigrant visas like visitor visas,
except for one non-immigrant visa, which is the K1 category, which they haven't commented on yet. But we believe discussions that with a lot of lawyers that are working on this, that we already are under the understanding that because K1s are a non-immigrant visa for fiancés, but they are handled by the immigrant visa units. So even though they are technically in the Immigration Nationality Act, a non-immigrant visa, they are treated like immigrant visas as far as the way that they're processed. So if you are on a K1 visa, if you are working on a K1 visa for somebody where you're a beneficiary of a K1 visa application, and you're from one of these 75 countries, I would assume for now that you are affected by this. My guess is we're going to see a lot more clarification on this soon. But that's my understanding from right now, is that the K1 visa holders can assume that they're going to be impacted by this.
Right. And just, we're getting a question about how this affects those inside the U.S. The expansion what happened today does not affect those who are applying for adjustment of status in the U.S.
Yes.
Although there is the halt on adjudications for certain countries that was done previously does affect USCIS adjudications.
Well, let me amend that a little bit just to say that this announcement comes from the State Department, but if it is indeed being directed by the White House in the same way that the 39 country ban was, you can expect to see USCIS do what they did for the 39 countries, which said essentially, if we're going to look at that list, if you were covered by that proclamation, even though this is not, this shouldn't be covered by that proclamation, we are going to consider that as a reason to pause benefit applications for everybody from the 39 countries. I don't know this for a fact, but I strongly suspect that we're going to see a similar memo expanding out the list from 39 to 75 countries that are affected by the benefits pause. So it's not the case yet. And that's going to happen, but you should be, I think, not naive and assuming that this is the end of the discussion and there's not going to be any more effects for people from these countries. But that's something that I'm expecting will happen. I will say, related to that we at Impact Litigation this afternoon, we made the decision that we are going to take our visa ban case that I was just mentioning a couple of minutes ago, and we are now taking applicants for that case for the rest of the countries, not just the 39. So I'll just show real fast the page for that. Hang on here. It's gone. But if you go to Ari, do you have the banner up for Impact?
I'm not logged into the account, so I don't have access to the banners. Sorry.
I'll put it up in a second. But Impact Litigation, if you're affected by this ban and you're interested in being a part of this litigation,
do you want me to? I'll have to log out for a second.
I think this link should still work. Oh no, it's got a new link, so don't ignore this. And I'll put the new one up in a second. Hang on, there we go.
Okay. While you're doing that, do you want me to talk about?
This is the new link. It's the same address, except it says, instead of 39, it says 75 country on there. So screenshot this or take a picture of it with your phone on there. I'll put it up again. I don't know why this new thing is very annoying, where it times out after 10 seconds. But the hopefully you got it on here. And then we anyway, so that's proceeding. So we're hopeful that our legal theory will carry sway with the courts. We filed this case actually in for the benefits pause in Atlanta, which is not normally the place that people think of. But when we sued on behalf of the students, about 250 students, to get their SEVIS records reinstated, that was the court we sued in, and we got a very good result for that group. I'm not sure yet where we're filing for the visa ban. I mean, sometimes what we're looking for are courts that have considered the issue before. So, when we're dealing with a lot of plaintiffs from a lot of different places, that gives us the ability to be thoughtful about which is the most appropriate place to sue. So we will see. Well, we could sue in D.C., where the State Department is located. We know we have a lot of positive law there, much of which was made by the lawyers at Impact. So one way or the other, we'll have that will be known in the next couple of days, because we're actually filing the suit. So Ari, I'm thinking that's all I wanted. Oh, one other thing. Ari, did you notice something missing from the State Department announcement? No information on national interest exceptions.
Oh, yeah.
So we don't know that, this was a very short announcement about it. We don't know if it's based on.
They said there's an exception for dual nationals that are applying under a passport of a country that's not listed.
Yeah.
They're exempt from this. That's the only exceptions that they listed.
So I am guessing that they will institute some kind of national interest exception process, but it's not entirely clear if it's going to operate the way it does with the others. Now, with that being said,
well, you say that, but I don't think that's true, because they're saying no immigrant visas will be issued to the nationals during this pause.
So Ari, what about like EB5s?
They plan to make an exception to
EB5s. Are they seriously? This would be a great lawsuit. Just EB5 EB5 suing, saying
all employment-based cases, especially.
Give me a break. You're calling me a potential public charge, and I'm investing $1 million in a U.S. company and creating jobs for 10 workers. That is chutzpah. for the to use the Yiddish term. So that's I would expect probably that they are going to cut
aliens of extraordinary ability
in business.
Are they still have the same concern for aliens of extraordinary ability who are what they love to
National
call
interest
the Einstein
waivers.
visa?
You really think somebody that the USCIS has already said is worthy of a national interest waiver, that they're providing a significant national interest to the country, but there's a greater risk of letting them in to benefit the national interest in the way they want because they're going to be defrauding welfare and get benefits that way. I mean, it's really pretty silly that they made this across the board, but that's what we're talking about. So nothing in there about exceptions that are going to apply for any broad categories. There are doctors that have they come into the U.S., they train, they get a physician national interest waiver, and for one reason or another, they're going. Sometimes they'll go for a sabbatical abroad. Sometimes they're going back to deal with a family member, and they're going to process through an immigrant visa to come back in. And now, basically they're frozen out as well. And of course, they're telling them that if they want to try and come back in, they're going to probably be subject to the H-1B $100,000 fee. So I could come up with probably, I should just ask ChatGPT to come up with these, but there's probably 100 different scenarios that I could come up with that would make people gasp as far as how ridiculous a policy like this is if you don't have a national interest exception or have or start eliminating categories. So that's that. Why don't we move on, Ari? I know, do you want to talk about the good news story for the week?
So the good news,
Right.
religious workers.
There's only one, religious workers. So Ari, what happened today?
Yeah, so today, USCIS, DHS issued a interim final rule that's effective today that gets rid of the requirement for R1 visas to leave the U.S. for a year in order to be eligible for an additional 5 years. So just to explain, R1 visas are temporary visas, non-immigrant visas for religious workers, also those in religious vocations like nuns and monks, as well as ministers. Ministers includes rabbis, imams, priests, religious workers. So this category is, highly used by churches and other religious institutions to bring in ministers and religious workers. There's a limit of you can get the R1 for initial 30 months, and years. You can get an extension for an additional 30 months, so a 5-year limit. And up until now, there's been a requirement that at the end of the 5 years, you have to leave the U.S. and stay outside the U.S. for a year in order to be able to apply for an additional 5 years. And to get the R1 beyond those 5 years. Similar to how it is with the H-1B, but the H-1B 1-year requirement is actually part of the statute, whereas this rule was actually just made to copy the H-1B rule. There was no specific time frame in the statute. It was just a 5-year limit. So what they've done is they've gotten rid of the 1-year rule. You still have to leave the U.S., but you can, as soon as you can get the visa from a new R1 visa, you can return on the visa. So you can't extend your status beyond the 5 years, but you can get a visa to come back in at that point and be eligible for an additional 5 years. And the reason why this has become very important is because the category for the immigrant visa, the green card applications that is normally used by religious workers, is the F4 preference, the fourth preference. And was it 2 years ago? I may be off on the time frame there. They changed the rules so that, or actually the rule sunset so that visas, there's now a very long wait for visas to become available in that category, which means that it takes longer than 5 years to get a green card in that category, which means without this rule, you'd have people age out and have to leave the U.S. and wait outside the U.S. till the visa becomes available to based on the job that they were being offered right then and there and were doing.
Right. Yeah. So it's lets us, some religious organizations looking at alternative green card categories that might not be backlogged as long, like EB2 with a perm, for to demonstrate that U.S. workers are not available. I did a consultation, I had an email exchange with a member of Clergy Today who didn't know about this yet, who was wanting to set up a time to talk to me about EB1 on there. But basically, like, these are categories not well suited for religious organizations, but they've been forced to look at those in advance. And Ari, I wanted to mention sort of why this happened. You may say, well, why did the administration agree to do this, since they seem like they hate immigrants across the board? But as is often the case, there is a litigation story behind it. And this was, you kind of set the backdrop, which was this change in 2023 that led to very long green card waits for the EB4 category. And in the summer of 2024, the Catholic Diocese of Paterson, New Jersey, and 5 of their affected priests sued DHS, the Department of State, and USCIS. And in the lawsuit, they argued that the 2023 change would cause severe and substantial disruptions to the lives and religious freedoms of the priests and the faithful that they serve. So a few months ago, the lawsuit was voluntarily dismissed because the USCIS promised that they were working on a rule that was going to render that lawsuit moot. And that's in fact what happened today, which was this rule that they were promising in that other lawsuit was dropped today. So that was the story that led to it. And I think the administration realized they were very likely going to lose in that case, and they might have been forced to make changes, beyond what they wanted to. Here, this is sort of the easiest change that they could possibly do. And by the way, are you still, the 5 years when it ends, you no longer have the gap, but you have to leave for a year, but you still have to leave the country.
You still have to leave.
At the end of the 5 years. So
if you time it right, it doesn't have to be for long, but you do have to leave.
Right. So that's obviously bad news for people from banned countries.
Right. Especially with the news that's come out. Yeah. Any country that you have a ban or a pause on non-immigrant visas.
Right. And so that's why I'm wondering whether
outside the U.S.
Like, for example, Nigeria is a big country that supplies Catholic priests to the U.S. I believe they're on this country. They're on the ban list right now. This voluntary dismissal. I am wondering whether that lawsuit might spring back to life if it looks like, on the one hand, they've allowed this to be solved with the changes in the.
I will say that Nigeria is on the partial ban, so those on the partial ban, our ones are not affected.
Okay,
but
they're not on the 75 country. Well,
75 country is immigrant visas,
right? But there, I guess the issue is, all right. So let's pick a different country then.
Right. I mean, we got a whole bunch of countries.
We got 39. We got 39 countries where our ones are banned on there. So that's, that being the case, I wouldn't be surprised to see that litigation where they would go back to the judge and say, "Hey, this is nice, but they have created a new problem that essentially, what we wanted was the ability to file adjustment applications. We're not able to do that."
Right.
If people are banned from coming back into the country.
And then there's another issue that we were discussing that it shouldn't be an issue, but we can see it being an issue, is that the R1 so there are, to explain to those watching, there are what's called dual intent visas, and then there are non-immigrant intent visas. So, for example, on one end, you have H-1Bs. So with H-1Bs or dual intent visas, you have the ability to you could have an application for your green card pending. You can, when you're applying for your visa, you could tell the officer, I'm planning on applying for the green card as soon as I get into the U.S., and that would not affect your eligibility for the visa. On the other end of the spectrum, you have your complete non-immigrant visas. So, for example, a visitor visa. Part of a visitor visa is you have to show that you do not have immigrant intent, that you are not going to stay in the U.S. and apply for the permanent residence once you get here on the visitor visa. The R1 is kind of in between. Okay, the guidance, the Foreign Affairs Manual says dual intent is allowed, but you still are subject to the rule that requires non-immigrant intent. So you still have to show that you are going to leave the U.S. at the end of your R1 and or at the end of your authorized period of stay. So we don't know how that's going to play out, because we have seen people get denied for the R1 visa under this rule, with the officer saying you didn't show that you were going to go home at the end of your R. And while the Department of State guidance specifically says that this shouldn't be a basis, it's very possible that we will see applicants who are, having the immigrant visa petition pending for them or approved for them, the I-360 approved for them, being denied because they will not be able to show strong enough ties to their home country, especially if they've been here for more than 5 years, working in the U.S. and have clear immigrant intent. So we're going to have to see how that plays out also.
You know what, Ari, I feel like on that one, the administration kind of puts themselves in a bind, because if you actually look at the rule that came out today, there's tons and tons of, I just did like a search of the document on how many times immigrant visa comes up in there. And they make it pretty clear that the reason why this is necessary is so that is because people are interested in applying for green cards and they're in this situation.
They do.
That's the whole reason for it. And I think once if we start to see consular officers denying on this particular issue, I am guessing that there will be litigation, and the litigation is just going to have, Exhibit A is going to be the actual rule, where they talk extensively about the whole reason they created this litigation. I mean, they created this new rule was to facilitate green card processing for religious workers. So I'm not as pessimistic on that, as I probably am on a lot of other things regarding this administration. So that's the good news of the week. And then, Ari, we did have I shouldn't laugh, but you can only basically laugh at the ridiculousness of what we're dealing with. We have one more story or two more stories?
We have a couple. We have 4 more stories.
All right. What's the next one?
All right, so we can talk about. So this naturally goes into the visa bulletin.
Visa. Yeah.
So the new visa bulletin came out, which goes into effect February 1st for the February visa bulletin. The news is no news. Very little movement in the visa bulletin for February, between January and February. So the categories that we saw movement in. I misplaced my notes. Where did I put them?
You better have them, because I don't.
Here we go. Okay, sorry.
Andy.
Okay. Okay. So we saw very little movement in the family-based. we saw in the F2A category, there was movement from of 2 months across the board. In the F2A category, that's for spouses and siblings and children under 21 of permanent residents, of green card holders. And we saw some movement in the F1 category and F2B, F1 being adult unmarried children of U.S. citizens, F2B being adult unmarried children of permanent residents, but only for Mexico. For every other country, there's been no movement. So that's the only movement we've seen in the family-based side. On the employment-based side, the only movement we saw was in the EB3 category, third preference for professionals and skilled workers, not including those from China and India. We saw some movement. Otherwise, everybody else has stayed exactly the same. And it seems to me like this is an early start for Department of State to be not only slowing down. I mean, there's pretty much they kept a hold on it. You know, we see it sometimes the very beginning, the October, the very beginning of the fiscal year, where they try and get an idea of what the rush is going to be. We also see it, you know, usually not till July or June, July, August. So I don't know what the thought process is there. I haven't seen an explanation yet as to why they determined they had to hold it off like this.
Yeah, generally speaking, I mean, there doesn't seem to be politicization in the visa bulletins themselves, or, you know, it's rare that happens, and it seems to be still done in a relatively professional way. But I agree that it's sort of like, it's surprising to me. I'm not seeing anything to indicate, you know, an increase in demand in any of these categories, unless this is kind of reflecting, you know, these surges of demand that happened in the past in terms of when people applied, where they're starting to come up. You know, it's sometimes hard to tell. It's like, if there was a big increase in applications during a boom, but there was like a 7 or 8 year wait, then when those cases come up, you may say, well, why is this category so slow right now when the economy is not doing much of anything? And it's because of that, because it's you're not really looking at what's going on right now. You're looking at what's going on for the groups that are close to becoming current.
Yeah, but that's not one category or one thing. This is across the board. We're really seeing that. Except for
I get it. Yeah, no, it'll be interesting to see if we get explanations. I'm not sure.
It seems like it feels like it's political. So one thing we didn't talk about with, you know, the topics crossing over, if the bans on the issuance of immigrant visas holds or continues for, you know, any real period of time, it may affect movement of the visa bulletin and of ability of those to file and to have applications adjudicated for those in the U.S. in the immigrant visa categories. If the visas are not being issued outside the U.S. at the consular posts for 75 countries, then we should be seeing adjudication, you know, issuance of visas quicker under the visa bulletin for those in the U.S. It creates a kind of a weird.
The only problem is they don't break it down that way, though. Like, how do they, you know, I guess they sort of know.
They have to issue a certain amount of visas each year.
Right. I mean, I guess what they would do is advance the dates really quickly.
Right.
Knowing that they have enough adjustment applications pending that they could get the job done.
Right. So that's what I'm saying. We may see adjustment applications advance quickly and get adjudicated quickly. Again,
it's not. Yeah, it's real. It's sort of like, it's not that it's the visa bulletin that would advance quickly to account for the fact that they need to get that group, that they have the supply is shifted over to the adjustment side.
Right.
and they have to get those cases adjudicated before the end of the fiscal year.
Right. So, I mean, that's something that,
Yeah.
a long-term thought process there of what may be affected.
It's kind of like, I hate to pit immigrants against immigrants, because goodness
Right,
says that's happened too many times on too many issues. But that's essentially like where you sit is how you see the world. If you're sitting in the United States as an immigrant who's filing for a green card, you might see things a lot rosier picture because of this than if you are, trying to bring your elderly parent in from outside the country, who's sitting and waiting in their, the home country patiently, and subject to the ban. So, okay. Ari, what's the next story?
So also just again, segueing into the next category, also want to point out that under the February visa bulletin, we are seeing the F4 category, which is for the religious workers that we were discussing before. They are now becoming unavailable for February because the reason why it's listed unavailable is because of the expected government shutdown. So because of the expected government shutdown, or technically that's not what it is. Technically, the issue is that they issued a stopgap extension of F4s with
Conrad 30s.
And those that ends at the end of this month. Yeah. So they do not know if there are going to be visas available next month under the F4 category. So they made them unavailable. You won't be able to file for them if in February, if there's no extension of the F4 rule.
Now, Ari,
into what we can expect otherwise if there is a government shutdown at the end of the month, beginning of next month.
Hasn't the government already shut down largely for big chunks of the immigrant population, though? We have 75 countries where they're not working on immigrant visa applications. We have 39 other countries where they're not working on non-immigrant visa applications. We have a benefits pause at USCIS for 39 different countries. It just seems like in one place after another, nobody's actually working on any of this stuff. They've all been paused while they work out, these theoretical vetting processes, which are never going to be announced. And they're never, in my opinion, they're never going to lift these pauses until
they're never going to be enough for them.
Yeah. Well, until the court tells them they have to lift the pause, they're not going to lift the pause. But so you're already, people are already effectively living in a government shutdown. But it gets worse when we get to the end of a line as far as the rest of processing that would normally take place. USCIS benefits should continue operating because they operate with fees, and generally speaking, if they don't depend on Congress to allocate money for their particular programs. That. And we'll as we get closer, we'll talk more and more about what it means. Goodness knows we did a lot of briefing on this in the fall when this was the last time this was an issue. But it is worth. But Ari, what's the end date?
The end date is the end of the month.
Okay, so just keep that in mind. You may anything you want to have filed that you have control over. You might want to at least have awareness of how a government shutdown would impact.
Right now, just kind of go through what's impacted, what's not impacted. So, a lot of immigration is fee based. So there is either they're not subject to Congress budget, but so for example, most USCIS adjudications do continue during the government shutdown. Where you get affected is Department of Labor adjudications. So labor condition applications and labor certifications and prevailing wage determinations. And, there's H2Bs, H2As, those.
What about, but I mean, I know a lot of people that watch this are in the middle of perm processing. They're not going to be able to get to the I-140 stage until they get a perm approved, and that's not going to happen during a shutdown.
Correct.
Yeah.
Correct. And so that's, that comes into play there. It's really just going to depend on how long the processing takes, how long the process takes for them to come to an agreement and not have a shutdown. I don't think there's any chance of there not being a shutdown. I think it's just a question of how long it'll be this time.
Yeah, I mean, there will be an immigration issue that is, it's a little early to say, but we haven't even I talked about it last week, what was going on in Minnesota, and I don't think we need to add that much to it this week. It's been all over the news, and it's really hard to avoid it, and people are well aware of what's been happening with ICE in Minnesota. But the ICE, one of the things that they're trying to negotiate is a substantial increase in funding for ICE. That was part of that big, beautiful bill, but that's just basically sets the priorities. And then Congress has to actually make appropriations for this. And that's when these kinds of shutdowns come into play, where, will the Democrats go along and say, yeah, we're going to continue with that, or are they going to, is this the time that they're going to essentially say, okay, we're not crossing that line anymore? And I wouldn't, it seems like they've caved pretty much across the board on that particular issue for years on there. But interestingly, this week, there have been 3 polls that came out in the last 3 days, each of which said for the first time that more people in the country agree with the principle that ICE should be abolished than that ICE should get more funding, and that's the first time public polling has ever shown that, where more people are against certainly against increasing funding for ICE, but actually calling for the abolition of the entire agency. So it used to seem like an extreme position, and now it's the plurality of people in the country taking that position, at least according to these 3 polls, one of which I think was YouGov, which is one of the major pollers that's out there. So take it for what you want, but I think that, immigration very possibly could be one of the hot button issues in the budget negotiation, and could be the issue over which they, the Democrats might decide to hold out for a while. All right, Ari, we only have a few minutes left, so I do want to take a question or two on here. Yeah. So what do you got next?
TPS for Somalia was announced that they are not extending it. It's going to be ending March 17th of 2026.
Somalia, the administration's favorite country. It's not a surprise. I will say
that's right. It's their favorite country of the week. What's their favorite country switches every couple weeks, but
and how long has Somalia had TPS?
Since 1991.
So 35 years on there, slightly less than, I think that was one of the first things that happened after I started doing immigration work. I became a lawyer in 1990 and started doing the immigration work probably about a year after that. And I remember that vaguely back then, but I did want to point out that, you may there's been all these lawsuits in the TPS space because the administration basically hasn't found a TPS that they liked for any of the countries that were on the list. And in many cases, courts have said, no, you cannot end TPS. And the reason why, it's very easy to, the administration has very broad authority to create TPS for a country. They don't get that same authority to get rid of TPS. They have to actually show that they went through a process of investigating to determine whether the causes that led to TPS being granted are still around. And they haven't done squat. And Somalia is in no better shape than it was in 1991. So I wouldn't be surprised to see litigation in this space, and I wouldn't be surprised to see successful litigation in this space because the administration never does their homework. Okay. Anything else?
The other one is premium processing is going up as of March 1st. The premium processing fees are going up. It's not relatively, it's not a huge amount. But for example, H-1B premium processing is going up from $28.05 to $29.65, so $160.
Yeah.
But that's, that ain't
Money's
nothing.
money, though. It used to be $1,500. So
Yeah, it used to be $1,500, then it was 25, then it was 28.05, and now
Yeah.
it's going to be 29.65.
So
I don't have
be
numbers
aware of that.
for the other categories that are changing, but the changes seem to be around that $100, $150, $160 upgrade for filing fees, and that goes into effect March 1st.
All right. Are you pick? Well, we got 4 minutes. We might be able to get 2 questions in. So pick one and then pick another.
Yeah, I mean, so there's just some questions about, can you apply for the lawsuit if you're not yet affected because you don't have the
You must have something pending. Yeah. You can't do it based on your plans for the future. That was easy. Next.
Yeah. Let's see. Let's see. And again, the specific thing they were asking about, they have an M400 application pending, and they're from one of these countries, and yet so far N400s are not affected by the 75 country list. The new ones are not affected, but again, we may hear that we are. Let's see. So one question was, are we suggesting that the dates won't move further by the end of this fiscal year? No, that's not what I was suggesting. I do expect the visa bulletin dates to continue moving. It's hard to predict what's going to happen, and I don't know why we're seeing a freeze at this point. But no, that would be extremely strange if in January you have a freeze and the numbers don't move, the visa bulletin doesn't move till the end of the year. There's definitely going to be a lawsuit for that. Well, we'll start the lawsuit at some point for that if they try doing that. So that's not what I was suggesting. I was just saying that it's strange that this early on. So it might mean that, Department of State for some reason thinks that they have enough I mean, what it should mean is they have enough applications already in hand to adjudicate. But I don't think that that's the case. At least we haven't seen it at this point, that that's the case. So we'll all have to see together what happens in March and April at that point, or if Department of State tells us more about their thought process on this.
We can take another question. We still have 2 minutes.
Okay. Question about if we're seeing approvals on people who applied in 2021 and that's been waiting because of retrogression. Yes, there, have been seeing clients who have had their cases put on hold because of retrogression, and now the numbers moved up that we're seeing adjudication.
Just Ari, from a technical standpoint, when that happens, when the dates move forward, is the government pretty good about catching that and notifying people, or is you have to be proactive and pushing things?
Well, I mean, they do have a process in place of, there's supposed to be a check where each month at the beginning of the month, or whenever the visa bulletin comes out, I guess, for the following month, they go through and have a way to pull it and check it. I don't know how effective that process is. I don't know exactly how it's done. But there is a process in place, and for the most part, they are. It doesn't happen right away. In other words, if yours retrogression and your number becomes available, that doesn't mean that right. If it becomes available in February, that doesn't mean your application is getting adjudicated in February. It might be March or April that they get around to adjudicating it, just based on their how quickly they're moving. But for the most part, we see it. Now, if you see if it's taking a particularly long time, we suggest doing things like congressional inquiry, But I give it, I wouldn't do it in the month it becomes available. That's not really helpful.
Unfortunately, if it becomes available and you're subject to, and you're in one of these benefits pauses,
Right.
you're not going to get an adjudication until the benefits pause is fixed on there or the lawsuit is successful. But it's and it's
and just to explain that also the benefit pause, it's a pause in adjudication of benefits. It does not stop you from being able to file for the benefit. So that's important for people to understand that you can, visa becomes available on the filing chart for those months that we can use the filing charts. Like in this upcoming month, both categories we use the filing charts, dates for filing charts. You can file when you're able to, even though that won't be getting adjudicated anytime soon until this is resolved for those countries.
Yeah, Ari, I don't know if we mentioned it, by the way, when we talked about the 75 country ban for immigrant visas that came out, but it's a similar thing. You can apply for the visa application. You can go through the whole process of, doing everything online, getting everything that you would otherwise be doing to process an immigrant visa application. You can even attend an interview, but they're not going to issue the visa until this new policy is lifted. And it's kind of the same idea where here you can have an adjustment application pending. But if you're in that 39 country ban, you're not going to be able to extend your 765 work authorization. You're not going to, and you're not going to get a final adjudication of the I-485 if you're in a retrogression situation. And it's although I don't know who's retrogressed other than India. So India would presumably not be affected because they're not in either of these bans. So maybe that's more theoretical for people in the future than it is going to affect any current group.
Well, so they had their own halt on visa issuance, or not halt, but they pushed back.
Yeah.
On scheduling of interviews. They canceled a bunch of interviews and pushed them back to March, most of them, for non-immigrant visas. That's for their extreme vetting. Social media vetting is the reason they said they were doing that.
All right, we are going to end here, and maybe next week will be. We can always hope that next week will be a slow news week in immigration. Slow news is good news, generally speaking, with this administration. So anyway, we'll see you guys.
But that's not likely to happen. So we'll probably have lots to talk about next week.
All right. See y'all. Bye-bye.